pouvoir, voilà, évidemment, on peut accepter, mais c'est une inscription tardive, non?
Oui.
Il faut juste voir quelle est notre compétence, qu'est-ce que nous pouvons faire.
Bah, je pense nous rien.
Hello to everyone. I can't offer you a dance show. I hope some of you may have seen the dance show in the lobby, which was quite impressive. So we are not dancing, well, maybe dancing intellectually, I don't know. We are talking today still about religious symbols. Remember that we examined last week the US case law. We saw that there are different, I would say, models, paradigms, how to interpret the no establishment clause, strict separation, which the court actually considers that not really fully realized. And then we saw the two main competing models, accommodation, which is a no coercion framework, and neutrality. We saw that the Supreme Court now, with the conservative majority, has abandoned the neutrality framework. Neutrality being, I would say, the framework was mainly the Lemon test, although you have to make sure that you have a secular purpose and the effect is also secular. And now we read the Van Orden case, which was a case before where we still had quite a balanced Supreme Court, but it, I think, foreshadowed already the approach which would be taken as it was written by a conservative majority, so rather a coercion framework. Today we will be traveling to Germany and to the European Court of Human Rights, and we will see that the approach there is also a little bit different. I would first like to give you a little bit of context about Germany. We have German students, so you feel free to step in, although you may have better knowledge of the German constitutional framework than me. I would say first, quite obviously, you have a right. It's enshrined in Article 4 of the Basic Law, which protects religious freedom. It's a right which is, in the German terminology, protected without reservation, meaning that you can limit it, but only for values which are also enshrined in the Constitution. So you need important values, interests, which are found in the Constitution itself to limit freedom of religion. Then we can see a specificity in Article 7, paragraph 3 of the Basic Law, which I think also shows that the state-church relationship is different from the US, and certainly very different from France, which we will examine next week. You can see in Article 7, paragraph 3, that religious instruction shall form part of the regular curriculum in state schools, with the exception of non-denominational schools. So actually it is a mandate of the state to teach religion in the normal school curriculum. What goes without saying is that such a subject, if the state teaches religion, it needs to grant exemptions. So it's not compulsory for all students, but for those who want a religious education, they get it in state schools. That also means that it's paid for by the state. So financed by the state, but the instruction is generally done by representatives of the religious communities. Is that right? I'm turning to the German students, that it's generally representatives of the state community, of the church in question. It's a similar regime which you can find also in certain Swiss cantons. In Switzerland, church-state relationship depends really on each canton. The majority of cantons are closer to the German model, with the exception of Geneva and Neuchâtel. So I had religious instruction in school as well. There's always the church is sending someone.
Yeah, in Basel canton, for instance, the canton and the church, they work together. Here, it's independent.
So you could say, when you mention working together, it's a kind of idea of you can cooperate. Church and state can cooperate. The state, in a way, has not to be indifferent to religion. The state can, to some extent, also encourage and support religion. I can see it.
Is the religion classes that are being taught specifically a certain religion, or it's like we're going to do a study of all the world religions?
No, it's generally not religious science. You could have for everyone a class which would be more philosophical, presenting the religions. But there it's really generally also the churches are recognized as public corporations, at least in Switzerland, and it's the majority religion. So the canton I grew up, we had Catholic and Protestant classes. I think in Germany, there I need the help of the German students. I think maybe in some lenders, you may have also Islam, classes in Islam. And sometimes there's an alternative given that if you don't attend religion classes, you might have ethics or so. But I'm giving you the floor. I don't know who wants to say something first.
Okay, I think it depends. In primary school, I used to have only Catholic classes. But then in high school, we could have a religious class with all the religions, or like with many of them. And if you don't want to take religion, you could take ethics, as you said.
So you can't force someone to go to Catholic instruction, but it's still a favor done to a majority religion. And I say, yes?
My experience out of the religion classes were always really close with the ethics classes. So I never experienced it. I can only talk about my religion classes.
Okay, you didn't feel it like they impose or they only...
We did the same thing,
Okay.
but by different teachers. So we also learned about Islam and all the other religions, and it never really felt like
Okay.
we never prayed or did things like this.
Any other experience with religious instruction in school? In Switzerland, elsewhere?
It's not the priest who was
Okay.
I had in Brazil, but I was studying Catholic school. But our religious class was like every religion too.
Okay.
So each semester or each year we had focuses, and the teacher was someone. He was a history teacher and a theology.
Okay. So it wasn't, in a way, one religion being studied.
Even
And,
though he was a Catholic.
okay, it's cool. Someone else, yes?
At my school in Germany, we had you could also choose like which Christianity and stuff, like also like Orthodox and stuff, and there were like different classes for it. And for example, like in my class, we even had to like say a prayer in the beginning, like everyone all together, like we had to do it. Everyone stand up and say the prayer together.
For me, it was quite strict. I went also to a Catholic school, but for me it was Christianity and or Catholicism, and there was no debate. There was no let's talk about it. That's it.
That's it, okay.
It was private though.
So I think if you have a private Catholic school, you can, I think, expect to have classes like that. I saw someone else raising their hand.
Yes, I didn't have like a school, but my university was Catholic, and what we had was a subject that was Jesus Christ and the person of today. That was the name of the subject.
Okay.
Another religion that not religion, another subject which I think gave us a openness, I would say, but the Jesus Christ and the person of today was really Catholic.
Okay.
It was really something to learn about Jesus.
So I would say from the point of view, I mentioned it last time, from international human rights law, you can have two models. So either you have a general class ethics, open, teach about different religions, not in a missionary way, that is okay. But if you want, the state can have, say, well, like Germany, we offer religious classes, and that could be just focusing on Christian religion, maybe even opening with a prayer or so. But then it can't be, obviously can't be mandatory. You need to have an alternative. I mean, things also evolved. I had more classes, which was there's only one right religion, we were told, and that's the Christian religion. And well, I had a bit of trouble with that. And I'm telling you my life, that's maybe a bit weird, but well, I have a mom who's an Indologist, so I was already suspect. They would ask me, do you meditate and do you burn incense sticks? So I was the suspect one in this Christian class, and my questions weren't always very popular, but well. It wasn't unconstitutional, that's the main thing, because my parents could have asked for an opt-out. So returning to Germany, here it's just a clear sign that it's not a strict separation. You'll see, for example, in France it would be unthinkable. In the United States also it would be unthinkable that the state pays for religious instruction in school. Then what is also interesting, just that you have basically the Basic Law, Article 140, refers to the previous constitution, to the Weimar Constitution, also for some provisions on the relationship between state and church. And we have there Article 137.1 saying that there won't be a state church. You have basically, I know we don't use the second reader very much, but you have in the second reader the Basic Law, and you can also read the provisions then of the Weimar Constitution. What we also find in the Weimar Constitution is then, okay, first maybe I'll talk about neutrality. When you read the Constitution, neutrality is not mentioned anywhere. It doesn't say, religious neutrality has to be respected, but it is more an inferred principle, inferred from Article 4, freedom of religion, and also equality, the principle of equality, and the Weimar Constitution, according to which you cannot establish a state religion. There is also a specific article, Article 33, which talks about basically accessibility to public office. So you cannot reserve public office just to special religions. It may go without saying that I think a modern, I would say, a state cannot just want to hire Christian or some other religion, but it's interesting to see that it's explicitly stated in the German Constitution. Then another hint in the Weimar Constitution that we don't have really strict, I would say, strict neutrality. We can see that the state can raise taxes for the churches. So it's basically there is a church tax, and inferred from Article 137 of the Weimar Constitution. It says religious communities with the status of public corporations are entitled to raise taxes based on fiscal records and in accordance with state regulations. So again, the state here supports the churches by raising taxes and then giving them back the money.
So religious neutrality is when there is a cooperation between the state and the church?
So they consider, and it's the same in Switzerland, they will call this rather a relative neutrality. Do you remember in last class I was saying neutrality is often used as a term, and I was rather placing it on a spectrum, saying that there are different conceptions of neutrality. Probably if you said, in the US that this is neutrality, people would be very surprised. They would say, no, this is not neutrality. In France, we will see there's more a secularist regime. They also use the term secularism as implying neutrality, but it's a very different understanding. So also in Swiss textbooks, you will always find, except for the two secular cantons, it's relative neutrality, which means the state can cooperate with religions, etc. Do you find in the crucifix case, as you've read it for today, it was a very controversial judgment. Do you find hints that neutrality is not understood in a strict way? We can ask ourselves, what is the state maybe not allowed to do? What would mean, well, a clear breach of neutrality? It's not that easy to grasp. You can cooperate with religions. It's relative. Well, would you say?
The state cannot create a situation where a person cannot escape some symbols or other religious meanings which are given by the state.
So we will return to this idea. You cannot create a situation where people can't escape. I'm not sure this is really a neutrality framework. I think it would be rather a different framework, but it is linked, obviously, to the fact that they don't have strict neutrality. What framework would you link that to? The idea of saying you can't, people must be able to escape, avoid a symbol. Is it?
I mean, I'm not sure if this is exactly what you're looking for, but practical concordancy is one of the things they talk about, where like, how do we, if we're balancing rights here, not give it equally, but say, how do we protect as many of the rights as possible, like all of them as much as possible?
It's true that this principle of practical concordancy does play an important role. Now it is used mainly, if, as you said, if there are conflicting rights. Where is the conflict of rights here? What is in conflict with what?
Religious freedom of the person who wants to learn under the cross and the negative religious freedom of the person.
The negative freedom is I'm not supposed to be coerced, right, in my religion. And the argument, do you see a link between that and this argument, I have to be able to escape? So my claim is, this is my interpretation, that it's rather more in Germany, the crucifix case is more about the accommodation framework. It's about saying, well, it's not strict neutrality, because if you argue in terms of strict neutrality, what would you say? Who can do me a reasoning? We're not in. Imagine another court taking a very strict approach to neutrality. What would you say about the crucifix? You wouldn't insist that it coerces someone or that people can escape. That wouldn't matter so much. We're looking for the alternative reasoning.
You could also just say, well, it's a religious symbol, even though it also represents cultural things, tradition, and everything that's also linked to one religion. And neutrality would mean that you don't have anything linked to any religion in your classroom, so therefore, no matter what other rights are here, or which play a role in this case, but we don't have any religious symbols in our classrooms, and therefore the crucifix has to go.
It would be more, I would say, a lemon-type reasoning. You would say, well, it's a religious symbol. It's the state which puts it up. We're in a state institution. So what is the sign send? It's a religious symbol. It will send the message to the students who are not Christian. They are outsiders. Remember this quote also by the endorsement test. So it's not about, are these people feeling coerced? It's about saying the state here takes side. It favors one religion, the Christian religion, over other religion. And you don't need to talk about a conflict of rights. You could simply say, well, this is, basically a violation of state neutrality. In Switzerland, we had our own crucifix judgment, which is mentioned in the Lauzi case, which was about Italy, about the Italian-speaking canton Ticino. And it was interesting. Our Supreme Court mixed a bit both approaches. It quoted the US, the case about the 10 Commandments in school, which we didn't read, Stone versus Graham, saying, well, see, treats others as minorities. It has this exclusionary, it excludes. And at the same time, it said, well, it has an impact on students, referring more to Germany, so a bit more of a mix of reasoning. Very controversial. I was told that apparently some judges who had decided that case received death threats afterwards. So never underestimate the impact of symbols. People can get extremely passionate about symbols, go to great lengths to fight over symbols. And sometimes it's harder, because if it's about money, you can sometimes find a middle ground. With symbols, it's not that easy. So I just wanted, I returned to the German case. So I would say it was not, even, I think we probably, if we took neutrality out of the case, it wouldn't have such a dramatic impact. It was not a judgment based mainly on neutrality. Because otherwise you would just say, well, the state is taking sides, it's not possible. So maybe because we already talked about this balancing, so there's the positive right of students and the negative right. To what extent is the positive, do you agree with this framing? Do you think it is about a conflict of rights? Or does it go without saying it's a conflict of rights? If I send my child to a school and there is no crucifix, is it reasonable for me to say there is an interference of my right to freedom of religion? You say no?
The Americans say no.
The Americans say clearly no.
But at the same time, parents can decide on how they want to raise their children, and if a parent now decides to raise the children with religious beliefs, they could maybe say, well, the missing of a crucifix is really hurtful for my ideas and how I want to raise my child, and my child needs to sit in a classroom with a symbol of Christianity hanging on the wall, and say that it's interfering with the parents' rights.
And if I say, well, you can teach your child at home. And what do? We have a multicultural background. We have a Buddhist child and a Hindu child, a Jain and a Muslim. How all these people want now their religion to be taught in school? Is that a good argument? Not a good argument? No, maybe it's not about just judging the position taken, but certainly what we can see again, it's not a negative understanding of a right. It's more of a positive understanding. The state, it's not just about the state has to abstain. So because if the state just has the duty not to interfere actively with religious freedom, then you couldn't say, well, me as a parent, there is no crucifix and this is an interference. It's this idea that the state has also positive duties and somehow has to create room, a favorable environment for religion, with the difficulty that is, which I mentioned about multiculturalism. And you said before in the US that the reasoning would not fly because the understanding of fundamental rights is mainly negative. The state must not act and interfere. And so if you put up a cross, that you could say that is an act, it's an interference, but you wouldn't say you have a right to be in a way, in a school setting which reflects your beliefs.
We've had a lot of debates in the US about the use of the word God in the Pledge of Allegiance, of our kids don't pray in schools usually, depends. Normally they're not supposed to pray in schools, but you say, I pledge my allegiance to the flag of the United States of America, one nation under God. And that, even not specifying which God you're referring to, has been a big cause of debate for a long time.
Okay. Yeah, oath can be also a difficult question. There's a case by the European Court of Human Rights where you have to offer, for example, if you want to take an oath as a lawyer, you have to have an alternative. You cannot, it can't be the Bible or God, you need to find something. But just where we find, the German Constitutional Court clearly does frame it as a conflict of rights, the rights of the parents who want to have their children confronted to religion. And on the other hand, you have the negative right not to be coerced in the school setting. Maybe just references about neutrality. You can see, for example, it's on page 265, the last paragraph. The state refers to neutrality and also explains why it is important. That's a classic justification about religious peace, saying if the state gets too enmeshed and identifies with a religion, that will be a source of conflict. So neutrality as a means of securing religious peace. And at the very bottom of the page, the court says, even where it cooperates with them or promotes them being religion, this may not lead to identification with particular religious communities. So we can see the understanding that you can cooperate with religions. The state does so through taxes, etc. You can even promote religion, but you can't identify with it, which shows this is why you often talk about a relative neutrality principle. It doesn't mean you're really indifference to religion, no identification. Then the court also interprets neutrality as meaning that it doesn't mean in school, and I think that goes without saying that there are always some, religion has left some imprint on history and culture. So you cannot basically, I think, reasonably teach history or philosophy if you can never mention a religious phenomenon. So that's not meant by neutrality. But we're left now with this conflict. So we have the positive right of the students who want a religion and their parents. And on the other hand, we have the negative right of the students who don't, who basically are non-believers and don't want to be basically exposed to the cross. How do we solve this? The court refers to practical concordancy. What does that mean? It's a principle which actually was also, which we also have in Switzerland. And I was told, I always thought it came from Germany, but apparently a Swiss scholar was there first, so I don't. I saw someone else raising their hand.
Is it that basically something that you can't favour one right or one group over another? You have to kind of allow them all equal protection as far as you can?
And how do you do that? It's not obvious if you say, I want to grant both. You're right in saying it's not an approach saying one right trumps another. So it's not a kind of, one is subordinate or so. No strict hierarchy between rights. When would concordancy not be respected? Because giving equal importance, I think, is very hard to do in practice, but you will. I was wondering whether we can't simply say that it's about balancing, and you can't sacrifice in this process one right entirely to the other. So, but it's true that the German formulation is a bit more sophisticated. They always say also you have to maximize in a way both rights and make sure one is not really hollowed out for the other. But I think it does imply at the end of the day some balancing. What about the argument, well, let's do some maths here. I have 28 students, they are Catholic, and I have 2 students. Well, 28, unless I'm mistaken, will have more weight than the 2.
Numerical strength or social importance that does not come into it. And also it states the detection of minorities, saying that the conflict arising cannot be resolved according to the majority principle or the fundamental right.
So my idea was a bad one. It's not about weighing and putting weight and counting. So the court clearly says it's not a numerical strength is not an argument, right? In this, you can't. And as you mentioned, also it's about protecting minorities that plays a role. We have that. Where have we got it? The court talks about it twice. Maybe someone is fast. Yeah, we have it on page 257, the right-hand column in the middle, where the court says, basically, the conflict, we cannot resolve the conflict according to the majority principle, etc. For the fundamental right to religious freedom specifically is aimed at, in a special degree, at protecting minorities. And page 255, rather towards the bottom, numerical strength or social importance does not come into play. So clearly you can't advance that argument to say, well, it's just about what the majority culture is. So here we have a perception or a conception of fundamental rights as mainly having to protect minorities. You sometimes find other people with other conceptions who say, well, we have to give, more weight to the majority, etc. Here, this is clearly not the case. But I do wonder, and tell me what you think about it, just occurred to me now, but is that actually compatible with this idea of the positive right, that you have to favor the Christian students by they have a right to have the cross up also, this conflict of rights?
It's interesting because I feel like putting the cross up in the classroom, it doesn't just affect the 28 Christian students, it also affects the students who aren't Christian. So it's like sure, maybe they have a positive right, but maybe it should be interpreted in a way that doesn't automatically infringe upon the rights of the people who don't want that right expressed. So for example, maybe instead of placing the crucifix on the wall for everybody to see, there's time carved out of the day for a prayer for people who want to pray in a special room that has a crucifix, instead of having the crucifix in every room and having people who don't want that forced to see it every day, all day.
That's an interesting thought to say, well, we can, and typical of also balancing, do you think, are there less restrictive means? Can't we, in a way, take into account the interests of being on one side, but without coercing the others? But just for this, I think if we really say now that we want to protect mainly minorities, it still feels a bit odd to say that the Christian parents have the right to have the cross there. You would almost have to say, well, then the other religions should be represented as well. Because even if they are minority ones, they would also have some right. No, they didn't decide to remove. Yeah, they did decide to remove the cross, but not based on neutrality, in my view. I don't think that was the decisive argument.
The state must maintain strict denominational neutrality and cannot identify with one religion. And so that's why the public schools may not impose
I understood the case more that it's about this balancing and saying, as was mentioned before, it's not the numerical strength which plays a role, but it's more I would say, the intensity of the interference, where the court feels, yes, maybe you have this positive right to be exposed to your religion, but that is not as strong as the limitation of the negative right. But to refer what I meant before was more to say, if we really take seriously the idea that freedom of religion protects also minorities, so if we postulate a positive right of the state having to create room for religions, why would it be just for Christian religions? That was my question. And now, what makes this interference severe? Does everyone agree with that? The court finds it's a very severe interference for these. Let's take our example with the two students who have to, sit there and have the class in their classroom. Maybe, or maybe travel to the very back.
I think the interference is more severe for the two students because if you're a Christian living in a Christian majority country, like your religion is represented pretty heavily already, and you already probably, even if you don't recognize it explicitly, you probably feel internally that you are part of that majority. Whereas if you are part of a minority, you're more likely to feel acute effects of being an outsider. And so having that reminded in a state institution like a school I think would be a more harmful effect, particularly on young children. So that's why I would think it would be more severe.
So I think that's, again, we are returning to this idea of exclusion. If you're a minority, you can feel excluded.
I have a question regarding secular states. In the case of Germany, they are not considered a secular state?
No, not secular in terms of like France or so. So it's more of a sometimes it's, people mention a corporatist regime, which a relative state neutrality, that the states can cooperate with religion, has not to be totally indifferent to religion. So it's totally different from France, for example.
So, for example, Brazil is a secular state. So technically, if I want to go to a Catholic school, I have to pay and go to a private one. The public spaces are not going to be full of reinforcing any type of religion. But at the same time, we have a very strong political alliance that is evangelic. So, it's a bit confusing too on where to use the secular state and when we don't have a secular state.
I think the problem is that each country, also the terms might be used differently. You know, a country may say, the constitution may say it's secular, but have a different understanding that another country using the same term. So I would say if we use secular in the sense as the French use it, then Germany is definitely not a secular state. It is a state which is recognizes state neutrality. Well, it's certainly not the identification with the religion, but it cooperates with them. And here we can see that the court was relatively strict with the school setting, saying, well, but you can't have this cross up. Did the court say so much it's about excluding people, or what was the court's argument? Did it say, the other children will feel excluded, or what did it say? Why was it problematic? And there were minority opinions, which is quite rare in Germany. The two judges felt that actually there's not at all a severe interference with the negative right of freedom of religion. Remember, the negative right is not to be coerced. We discussed about it in the last week also with this Lee versus Weissman case, the school prayer at the graduation ceremony. And we saw that with that, the difficulty is to say what amounts to coercion. So is this an act of coercion? You are in a school and there is the crucifix. And what about if I walk now that it's Christmas and I walk on a town square and they put up a creche? Is that the same thing? Is it a difference? Does Germany now say, remember in the US, the interior designer, would they also turn into interior designers and say, we'll check, is the creche, accompanied with the reindeers, some plastic animals and other symbols or so? So I think you've summarized it very well. It comes back at different points in the judgment. You have it already on page 255, the right-hand column top, where the court says that basically you don't have generally a right to be spared from other manifestations of faith. So if I live in a multicultural society, I will see people having other religions. I might see religious symbols, but then, says the court, This is, however, to be distinguished from a situation created by the state where the individual is exposed without possibility of escape to the influence of a particular phase. So basically, it's a state institution, you can't escape, and the court says it, it continues on page 256, that you have to, basically it's this sentence saying that this, in a way you are compelled to learn under the cross. It's not the children's choice, you have to sit there and it's a duty. And then the court gives basically, again, distinguishes this situation, saying it's not the same as confrontation with religious symbols in the most varied religious, in everyday life. So that in everyday life, it's A, not the state which creates this, and secondly, we don't have the same degree of inescapability. So put differently, if there is, even if the state puts up a creche or a Christmas tree, I can pass. I don't have to spend my time there. And it's the second paragraph on page 255. The court talks about duration and intensity. In duration and intensity, the effect of the crosses in classrooms is still greater than that of crosses in courtrooms. And again, it's this idea of inescapability which is important. Put differently, the German reading is not that the state can never anywhere put up a religious symbol. So my example of the town square, it's Christmas, okay, we put something up, etc. But it's a question of the duration, intensity. Can you escape the situation, or do you just pass by? You can well imagine you may sometimes have borderline cases where it's not. The court also felt, for example, in a courthouse or in a courtroom, you can't have a cross. That would also feel like you're being coerced. The court also says, well, there is some, that certainly putting up the cross has an effect on the students. Question, can we demonstrate that? That the cross will have an impact on the students? It's not so obvious. If you had to empirically, basically, it is said on nor can the page 256, nor can the cross be denied effect on pupils, and but if we had to demonstrate it, not clear. So we have here a case, I would say the case refers to neutrality, but we can see that it does not exclude, that generally the neutrality, you can still promote, cooperate with religions. I believe maybe neutrality played a role in as much as the court here feels this cooperation did go too far because it actually infringes negative rights of the minority students. But I think the major part of the judgment, it's more about a balancing between competing rights. We saw how we get to this conflict of competing rights, this idea that the state also in a way has to act positively, allow room for religion in school. And then you have the negative right, the right not to be coerced as a student. And how do we solve this practical concordancy, saying here the impact on the negative right is just much stronger. It is an inescapable situation. People have to learn under the cross. Any questions about this case? Comments?
So at the end, what did they do?
So they did decide that you have to basically, that the cross is unconstitutional, and mainly because it is it violates the negative right, the right not to be coerced of the minority students. So there was this conflict of right, and the balance tipped in favor of the minority students. I think what happened in Bavaria is what I was told you, the German students can basically correct me, is that the Land adopted a law saying that the parents, as long as no one complained, they would leave the cross up. So it's also interesting, courts can hand down decisions. It doesn't always mean that they will be fully complied with, or there might be an interpretation of what the judgment means, which can be quite restricted. I thought it was interesting in Switzerland, we had our Lautzi case, I told you so, in the 90s. Obviously, it was about one school in Tessin, but I think the general message was clear. No crucifixes, at least in primary schools. Like 20 years later, in Valais, which is also a Catholic canton, they still had crucifixes up till one teacher blew his top and he took it down and he was dismissed with immediate effect. So then it was a labor law dispute where basically, I remember a colleague of mine was defending his position, saying, well, the cross should not be there. That was said, but so you can't assume that just because a court says something, there will always be compliance. And sometimes as lawyers, we have this effect thinking, it will be, the law will naturally be followed. So let's have a break and we'll see then how the European Court of Human Rights deals with the issue. I think we'll see quite a few differences to the German approach. So let's look together at this Laozi case. It's a case which was very controversial at the time. Just to explain a bit the procedure. So you had first a chamber judgment, 7 judges, and they found unanimously there was a violation of freedom of religion and also of the right to education in protocol number 1. And this judgment really stirred a lot of controversy in Italy. Within the European Convention mechanism, there is the possibility to defer a judgment to the Grand Chamber. The Grand Chamber is like, it's then 17 judges. It's not an automatic appeal. Basically, the idea is that the European Court can basically look again in a bigger constellation at issues which are important for the interpretation of the Convention. And there is like a filtering mechanism, a body of 5 judges, which will basically decide, is the issue sufficiently important or not? So here it was Italy, which basically said, we want the case taken to the Grand Chamber. The state could do so too. Perinček was another case, Grand Chamber. It was then Switzerland asking for the deferral. Here, Italy asked for the referral. The panel of 5 judges accepted, and we have a Grand Chamber judgment which goes completely the other way. You may have seen, I think there were 2 dissenting justices, so we have from a unanimous chamber judgment in favor of a violation, a reversal, basically 15 judges as opposed to 2 finding no violation. So I think what probably, and this is more a sociological observation, played a role is still also the fact that to see how much up in arms Italy was about this case. And there were also, you may have seen there were third interveners. So other states with more of where religion plays more of a role, they joined. And the whole initiative was coordinated by San Marino. I once met the agent of the government. He came and talked to me about the experience of the Laozi case, and they hired to represent their point of view a Jewish-American lawyer, Joseph Weiler. I don't know if someone knows Weiler. He's actually a specialist in European law, but a strong believer, Jewish by faith. And so the strategy was to say, we don't want a Christian. We need to have someone from another religion to defend that point of view. So this is just a little bit of the decorum of the case. Maybe we could start off with some brainstorming, and then we'll look at it more systematically. What have you retained from the case? What seems to be the main pieces of the argument? Maybe also differences to the German case. Are you convinced, not convinced? No violation here.
It can maybe be the context, because Italy is more a Catholic country, let's say. So it was not considered like a crime itself, because it's normalized that you on the streets you see a church. Especially like it's not the same as in the German.
So on the other hand, Bavaria is very Catholic. So you had a cross in a Catholic land, but maybe the question which arises is, to what extent has the European Court to take into account more the social context of a country? That you have a big diversity in Europe. You have countries where in Italy, undeniably, the Christian tradition, the Catholic tradition is very strong. Do you take that into account more or not? So clearly it did have an impact, and the question is, should it have an impact or not? But I think it's important to point to this fact that the court is clearly here sensitive to this.
I think one important aspect of this case was how much margin of appreciation the court should give to the state in how they... I'm not really sure.
The margin of appreciation, I think, is an absolute key term in this judgment. One of my colleagues once counted it. I must admit, I forgot what the number was. It was around 20. The court mentions, I think, margin of appreciation about 20 times. It's always like, and this is really, something quite typical of the European Court's case law. When you read the preamble, you have the principle of subsidiarity. So there is an eternal tension. The court has to protect rights, as it says, which are effective, concrete and effective, not illusionary. And at the same time, it's an international court. It should not be a steamroller and flatten everything. It should still recognize diversity. So how much margin of appreciation in a concrete case? And it's always up for debate with different conceptions. Just maybe, this is not a class now on the European Court, but there are certain criteria when the court leaves a large margin of appreciation. For certain rights, it will never apply a margin of appreciation. Anyone got an idea which rights you would not leave a margin of appreciation? The right to life or the right to torture, etc. It depends on your tradition. You'll go ahead a little bit. That's nice also. No. So basically, the margin of appreciation appears mainly within, from Article 8 to Article 11. Right to privacy, freedom of religion, freedom of expression, association, and assembly. It's when you read the rights, they're always structured as having first you describe the right, and then the scope, and then you have a limitation clause, which is quite large. And it requires then, it gives a broad range of public interests, which could justify the limitation of the right, and then it's the restriction, the interference needs to be necessary in a democratic society. And when the court looks at this necessity in a democratic society, that's where the margin of appreciation steps in. Sometimes it will say, now I'm being very strict. We saw it, for example, in Perinček. You remember our case study where the court, as it framed it as more of a political discussion, political speech, it will leave very generally little margin of appreciation. So it then depends also on, just given for certain rights, it will be also maybe, are we more at the core of the right? Political speech would be at the core. For commercial advertising, the court says, well, hands off, large margin of appreciation. Then you have other criteria. Did you see another criteria the court uses?
Yeah, it says that the crucifix on a wall is an essentially passive symbol. So this is a little bit like the passive argument in America.
So we will return to that. The cross doesn't do anything. It's quietly, patiently, calmly sitting on the wall. Okay. I'm not sure this is a real, maybe it can be linked to the gravity of the interference, that they feel it's not a strong interference. Other general criteria, what did the court also look at, which may impact the margin of appreciation? Or maybe,
There's consensus among other European states, which is not the case.
So it is this famous European consensus. So the court will look at what is the situation in the member states, and there are a lot of studies done, on this European consensus. Is it applied consistently? That also depends. Sometimes you get the impression the court has an outcome in mind and then will say whether it finds a consensus or not. In some cases, it even talked about the emerging European consensus. That was one of the Goodwin versus UK about transgender people and whether you recognize, if they changed sex, whether states have to legally recognize it. The court couldn't really say that there was already a strong consensus among the member states, but nevertheless found, well, it's an emerging consensus. Sometimes it's about how you frame it, what do you look at, really, But it's a criteria, and you will have cases when a state is on its own, then the court will generally say, look, sorry, you have to adapt. I'll give you an example. Dutchen is a famous case about Ireland was one of I think the only country left which would criminalize homosexual relationships between consenting adults. So there was an element for the court to say, A, it's a strong interference. So we're talking about the intimate life. So it's really the core of privacy, which is at issue. And we have a European consensus saying that it's not up to the courts or to the state here to regulate. A case basically which influenced the US Supreme Court. The court there quoted the Dutch case in, someone will know the name of the Lawrence versus Texas, I think, where the the US Supreme Court basically referred to the European Court. So you see different elements. Also, when something seems to be, I would say, morally sensitive, often in those cases, the court will then say, well, the domestic authorities, they have a direct contact with the population, they know better. We talked 2 weeks ago about blasphemy. There it's a bit the approach of the court to say, well, but it's a sensitive issue, morality and blasphemy, so hands off. Generally, when it comes to freedom of religion, the court tends to have quite a hands-off approach. Basically, it doesn't mean that there are cases where there is a violation, but we can see it here. The court basically repeats all over margin of appreciation, etc. And I think that certainly has an impact on the outcome. Have you found other elements in the case where maybe, I don't know whether you agree with them, not agree?
In relation to the margin of appreciation, it especially emphasizes it on the area of education and teaching, where it says the setting and planning of the curriculum fall within the competence of the contracting states. In principle, it is not for the court to rule on such questions, as the solutions may legitimately vary according to the country and the area. I think just the criteria here is it's not supposed to be indoctrination. We'll leave it up to you. We'll just check if it's indoctrination or not. But the rest falls within your margin of appreciation.
So the word indoctrination appears quite a bit, right, in the Lautsi judgment. And so maybe my question is, if you look at the case, would you say the court applied more of a neutrality framework or of an accommodation framework when you talk about indoctrination, etc.? Is that about neutrality or about accommodation? So I fully agree. Again, we have an approach, more an accommodation framework. Only that the court, I told you with the accommodation framework, the difficulty is what does amount to coercion, where you might have different interpretations. Again, remember Lee versus Weissman, where the Supreme Court feels subtle pressure is enough, and Scalia said, well, no, that is no coercion. Here the court basically, I would say, puts the bar quite high. You have to show its indoctrination, and that the influence, potential influence of a symbol is not enough. If you compare this to Germany, so we've heard today quite. I told you, I think crucifix is also more of an accommodation framework. But what amounts to coercion, I think, has been defined quite differently. For the German Constitutional Court, coercion was more to say, you have to be there, that is coercion, you learn under the cross. And the European Court says, no, that's not a problem, it's about indoctrination.
I think maybe that's where the margin of appreciation comes in. It's the European Court saying more like, the only reason that we could step in and interfere with a state sovereign judgment is if it's really gone too far, and we're going to leave it up to the states to decide exactly where is their line of, if it's within some more subtle, gentle pressure, is that allowed or not in their state? You get to decide, but we only will interfere in the most egregious circumstances.
I think the court doesn't say it that way, but that's certainly the reasoning behind, to say, well, and I think judges will probably never admit to it, but sometimes I think their reasoning can be result-driven as well. So here the result, I think, was we don't want to find a violation. We don't want to have Italy up in arms and refusing to comply. So you were raising your hand as well.
Yeah, it just also mentioned that we're not coercing because Italy opens up the school environment in parallel to other religions. So the government indicated in this connection that it was not forbidden for pupils to wear Islamic headscarves or other symbols. So you're not coerced because you have other options as well. So it's more of a liberal approach. You can see the cross, but you can also wear your religious symbols as well.
It's true that they did take into account that there's other religions are not barred, etc. Then the question is, for me still, I'm a bit wary not to put on the same level a state displaying symbols and saying students can wear, a religious clothing garment because that's the individual, whereas the state, I mean, it's a state institution. But yeah, so yeah.
And again, I think the problem I would have in this situation, the state tells me, well, just wear something else. We have the cross up there, and you can do whatever you want. What if you don't have this one symbol? For example, because you don't believe into any god or anything. So how do you then distance yourself from this?
So you're feeling it's not good enough to say, well, generally.
It's a little bit like it's an easy way out to say, well, it's your own responsibility. But I think that there might be situations where this is simply not possible to do for one student, and then also that one thing comes from the state, and you're 10 years old and supposed to, I don't know, do something on your own.
I also think it's not certainly an argument on the same level somehow. It's maybe additional to say, well, it would be obviously worse if we were in a setting where you put the cross up and then you say, but no one can show, I don't tolerate any diversity among the students. I think that would be worse, clearly. But I'm not sure that we may have different points of view, whether it's enough as a reasoning to say the cross stays there.
Part of the idea is that we're not wanting to target minorities or make them feel unwelcome, saying, oh, you can point yourself out further as a minority as your protection doesn't quite make sense in reality.
So there again, if you argue in terms of, that's generally the neutrality argument, to say don't make people feel excluded, etc. Did the court acknowledge or recognize that the European Convention imposes some neutrality or secularism on the states? Would have been one way of reasoning, the kind of lemon test on the European level, saying, well, the European Convention protects freedom of religion, and that implies also that the state, in a way, is...
The chamber found a violation.
But not the Grand Chamber, right?
No.
The chamber that went more into a neutrality framework. But here we can see that the Grand Chamber, so the 17 judges, actually followed, and that was the argument of the third interveners, saying this is not the role of the European Court. State-church relationship is so different from one country to another. Well, we will not impose here, one way of one reading, the idea of state neutrality. So we look at it from the vantage point of freedom of religion. Again, back to negative freedom of religion. You could coerce people, but the reasoning here being it has to reach the level of indoctrination.
Yeah, but also they took into consideration the cultural context. Because we cannot deny also that there are some cultural...
But that goes hand in hand with the refusal to recognize a uniform conception of neutrality. It's saying this goes too far, this is not within the convention. We grant the states a big margin of appreciation so that they can adapt then, according to as you say, the local circumstances. That's part of the reasoning, I would say.
But
Well, if you don't react to a judgment, then you accept it. And so it would have been a possible scenario that the Grand Chamber would never have been seized. But because Italy felt strongly about this issue, it deferred the case to the Grand Chamber. So the interpretation between the Chamber judgment and the Grand Chamber is very different. Yes?
I think it also has to do with the applicable law, because the court finds that the applicable provision was Article 2 of Protocol 1 concerning education, and not so much Article 9 of the Convention that is concerned with religious freedom. So, as the concern is not on neutrality but on education, I think it's the first concluding opinion that states that it's a conflict of rights. The right of parents to teach their kids as they wish, and the duty of the state to provide education. And there, in that duty of the state, there's a big margin of appreciation that must be respected by the court.
I think when the court applies the right to education, it's still for the religious questions interpreted in the light of Article 9. So I think, I'm not sure whether it's just because it's education that you have a broad margin of appreciation. I think it's also because the court does this comparative analysis and saying, well, very different between the various member states. One question we haven't looked at was, it comes actually analytically before, how do we interpret the crucifix? Is it a religious symbol or not? Because there's quite interesting development.
Something quite interesting is that Italy does a reference to that, and they don't necessarily see it as something religious, but as a part of their history. It's a historical development.
I think passive is something else. Passive is the impact of the... But it's first we have to say, is it religious or not, or is it cultural? So you're saying...
It's the result of Italy's historical development.
So Italy does frame it as saying, look, this is a historical symbol, cultural, it's our identity. They stress the national identity. You touch our national identity. That is European courts there get off. Yeah.
Sorry, think my thoughts. Yeah, I thought the Italian, like the lower court, like the Italian courts, their interpretation of both the cross, but also like Christianity and its role in Italian society was fairly racist, in my opinion.
Can you elaborate on that? I quite agree with you. But
I wish I had brought my notes. They had like very explicit lines where they talk about like Christianity being the sole religion in which charity is more important than faith, and how like it's only through Christianity that like the ideals of like
tolerance and human dignity.
Yeah, exactly, are found, which is blatantly false. That's a core of a lot of religions. It's also not particularly true of Christianity. Like it's partly for some people, but not. So I don't know. I didn't really agree with those the Italian courts, but I guess that didn't have a significant impact on how the European court interpreted it. But it seemed to me to raise a question of when does something become a cultural icon? And I don't recall how much they talked about this, but I think that was very important. That's kind of the discussion we're having. So anyway, sorry, I just wanted to...
No, I thought it's very interesting what you were saying. I think clearly the court was not, I think, much affected by this argument. It's not. The court says it's a religious symbol. It does not accept it's just a cultural one, because as history and religion are intertwined, at the end of the day, I think you would have no religious symbols left. You could always say for major religions, well, that's part of our history, and so. So the court, and also the US Supreme Court, remember, for the 10 Commandments, says the 10 Commandments are religious. Yes, they play a historic role as well. So it's not so easy just to say because it's part of our history, it's not a religious symbol. And maybe just because you mentioned these passages, which I also felt were a bit, I don't think... So, but I think what may have had an impact on the court is this strong insistence on identity, national identity, etc. For example, it talks about singularly Christianity, then is the kind of, and also interesting, they interpret the cross as a symbol of secularism. I think that's quite a stretch as well, is to say all our secular values of tolerance, all that is because of Christian religion. So you don't have a difference anymore between religion and secularism. That gets conflated. And then the cross is a symbol of liberty, equality, dignity. The French Revolution gets mobilized, which was actually, as a movement, rather skeptical of the church. And then it's this paragraph, page 260, 13.3, where the court says the logical mechanism, the lower courts, the logical mechanism of exclusion of the unbeliever is inherent in any religious conviction, even if those concerned are not aware of it, the sole exception being Christianity. All the others they exclude, the cross cannot exclude anyone, etc. And at the end of the paragraph, but that is basically not true for other religious faiths, so there's really one religion, Christianity, and all the others are, so, well.
Cultural meaning, because here I just found the passage 34 which says the court further considers that the crucifix is above all a religious symbol. The question whether the crucifix is charged with any other meaning beyond this religious symbolism is not decisive at this stage of the court's reasoning.
So the European court clearly says it's a religious symbol, and all the other historical, it's not really what the case is about. But what I think is interesting, and that's why I left it in the case, is the Italian court's approach, saying, well, actually it's not a religious symbol. It's the symbol of all our secular values, etc. And the only religion, which is tolerant and doesn't exclude anyone, is the Christian religion. That's certainly a statement I would never subscribe. I mean, it's very close to this idea. There is one right religion and all the others got it wrong. And I mean, they do say at some point, well, in history, maybe the Christian tradition has not always been the most brilliant in terms of tolerance.
I think that the German case is more strict,
Well, I would say, as we mentioned, so now we were talking about the meaning of the cross and looking at the saying for the court, it is a religious symbol. And then there is a difference with respect to Germany is more demanding in terms of saying, well, the cross as such is a form of coercion. So because you have to be there, the European court sets the bar at indoctrination. And with indoctrination is also then, what would then be indoctrination? What would that suppose? If I ask you, what does it mean to indoctrinate someone?
To impose an ideology or religion in a forceful manner.
And what about the cross? Could that be a form of indoctrination?
See the cross, or
We put up crosses.
is to teach someone to accept something.
So but I think the way the court, yes.
Simply by putting up a cross, you're not indoctrinating because the cross is just there. And you can acknowledge the cross, but the cross itself is not telling you, hey, you have to be Christian to, I don't know, get good grades or something. Maybe even without an advantage. But if the teachers are not pointing out the cross, it's just there. It doesn't really matter if it's there or not.
So the judgment makes it clear the cross itself, by being on the wall, is not a form of indoctrination. That's not what they mean.
Yeah, they specifically say there's no evidence that the display of a religious symbol in a classroom may influence pupils, which is like the exact opposite of what the German court said, which kind of just, without even citing evidence, or at least the excerpt we saw, says that it's unquestionable. So someone brings a case evidence of like indoctrination, or does there need to be like empirical, sociological, or psychological evidence presented?
So I think that was also one point I had in mind. It's interesting to see that the two courts basically have a very different approach. Does it have an impact or not? That the cross is simply up there. And I think they don't mean, it's easier to say, well, common knowledge would say that people might feel excluded. But that is more a reasoning courts employ with a neutrality framework. And as the court does not use a neutrality framework, it will then just be kind of presented as the lousy kids are just feeling offended, but it hasn't got any impact on their freedom of religion. You haven't demonstrated that maybe the children will, you know, become Catholic, or it hasn't got a proselytizing effect. Whereas I think Germany here is more cautious. It's interesting, I would say, if you want to leave a lot of room for religion, you will certainly not adopt the neutrality framework. That is harder. You will opt for an accommodation framework, and then you will say what counts as influence. The bar will have to be set high. So it's indoctrination, not just a symbol on the wall. And we'll also say, well, provide the evidence. Provide the evidence that really some kids will be affected and may not fully enjoy or their freedom of religion. Indoctrination, I think, would be, according to the court, I think the court mentions it at some point, it would be more active verbal proselytizing in favor of religion. So the teaching staff maybe, which would, I mean, the cross could be part of a whole indoctrination program. We could imagine, you know, teachers promoting all the time Christian religion, and you have the school setting to go with it. But here, I think when the court mentions that the cross is passive, it's to mark this distinction. It doesn't verbally, actively promote anything. It is a symbol, it sends a message, but not as strong as teaching off in favor of religion.
But maybe I agree a little bit more with the German perspective. As a parent, you also, if you don't want to raise your kid with any type of immersion or ideology of a religion, and you send him to school, you also have the right of your kid not being shown any symbol. Freedom of religion again. And if you don't want to be a part of it, why does your kid has to be thought about it or even like acknowledge it if it doesn't come from your household?
This was a bit my question. I think the European court doesn't frame it as a conflict of rights. It doesn't say there are the 29 parents in the class who have a right that the cross is up. That the court doesn't mention. It simply says, well, Italy has this measure which can be linked to tradition, culture, history, and now there is an interference, a possible interference with the minority, and it feels, well, actually there is no interference because there is no indoctrination. But the argument I made with the German approach, saying actually there is a conflict of right, that was a bit my question. Well, if I say the state has to create room, positive room for the religion in school, how do you do that if you have different religions? You cannot satisfy the Christians who want the cross and the atheists who don't want the cross. So that's why I'm a little bit dubious about this conflict of rights approach. But the outcome is then basically in Germany to say, but the negative right here is strongly impaired, and so in a school setting you can't have the...
It's like that popular saying of, my freedom ends when the freedom of others begins. So you are already going against the freedom of a Muslim or someone else.
And the European court here would say no, because it says, well, there is no interference with that freedom unless you prove it's indoctrination. So a lot depends, how do you interpret this coercion, this form of, how far does the negative right of freedom of religion go? The German Constitutional Court says clearly it does not mean you have a right to be spared any confrontation with a religious symbol, but a school setting is different. And the European Court feels even in a school setting, well, if it's not indoctrination, the passive symbol is not a problem. And remember the use of passive in Van Orden? I think there was a bit a similar logic to say, well, it doesn't do anything, it's just standing there. Then the court also refers to another case, and I don't know what you think about that. Yeah, now I have another question. The third interveners and Judge Bonello, they say basically that if you take the cross down, that would be not neutral. That would be promoting non-religion secularism. Do you agree or not agree with that way of looking at it? State action limiting now, showing hostility to religion, you take it down.
I found it quite interesting reading Judge Bonello's argument. He felt very passionate. He thought to make that anti-Christian vitriol and major agricultural vandalism. Taking down, he also refers to this whole freedom of religion and not secularism. So it kind of doesn't know what freedom of religion then mean. Could be equal neutrality to all religions because.
But here the claim goes further. I can relate to the argument to say the European Court should not impose a standard, and states may have cooperate more with religion. But to say if you remove the cross, that would be a violation of neutrality. Do you agree with that, or do you find that a bit debatable?
Coming from the United States, that's like the opposite of what I think. But I can see a situation where, like, families in a school, if the crucifix is removed and they grew up with it, they could view that as like an attack on their religion. But coming from the United States, where we don't have that tradition and history, I just view it.
And I think it's a bit hard to say, what does neutrality then mean? If the cross is up, is that neutral? If I take it away, it's also not neutral, so I don't know.
Yeah, but I think the problem is that in this case, if you now see that the cross is hanging there and it's not neutral by hanging there, then you have to just, well, you were wrong in the historical sense of having the cross up there for centuries, so you can either continue being wrong or you just get over it and remove the cross, and probably a lot of people will be really
Relieved.
about it and have a lot of feelings, but maybe for the long term forward, it's the more neutral version.
I think it's hard to say, on the one hand, to argue there should be no, the European Convention does not impose neutrality, so you can have a cross up, which clearly I think no one would say this is neutral, I believe. And then, but to say if you take it down, that's not neutral. So he mobilizes neutrality then in a way to defend the status quo. I did not find that very convincing. I think it basically means nothing is neutral, ever neutral.
Yeah, but then it all depends on the consequences. You need to see the reactions of people, as you said.
Yeah, but I don't think that neutrality should depend on people's reaction.
No, I mean, if something that harms, let's say, the national security or something, then you could, the laws can change, and then you can really dictate some things like, oh, this needs neutrality, this then.
I would also not link it to security or so, but I just wanted to draw your attention to this argument, because at the very beginning when we talked about freedom of religion, I asked you this question: would that be neutral if you have no signs up, for example? Or would you say that favors atheism, to show that neutrality is sometimes interpreted differently? And here Bonello comes with this idea, and the third interveners. And Weiler, in his pleading, apparently was saying a blank wall, that's not neutral. That is taking sides, you favor atheism, etc. Apart from that, someone mentioned also the Bonello's very strong language, which I'm not sure I would use it as a judge, to be very honest, but well, that's apparently his style of writing when he talks about cultural vandalism, Alzheimer's history. This court which sits in a glass box, how can it dare to... But when you look at the substance of the arguments, were there some there's a few, at least, which I would not endorse as such. I don't know if anyone read something you might not agree with.
It's just I had a question because he said that values like secularism
clearly, there's other case law where the court will refer to tolerance, etc., and these values. What Bonello's argument was here to say is that, and it should have been more narrow, simply to say that the convention does not impose one model of state-church relationship. It does not impose a strict neutrality. We can have more of a cooperation, it's relative neutrality. But to say tolerance is not a value of the convention, that certainly goes against the case law of the court in many areas. Also, freedom of expression, the court will say hate speech, extreme hate speech is against, a tolerant society, we can't accept it. And you will find freedom of religion cases where the court refers to tolerance, etc. Also saying, well, you have to accept this. Tolerance means I accept that you might criticize my religion. At the same time, okay, the other one should be tolerant. The court says not to be gratuitously offensive. If I return to Bonello, there was one argument I felt was a bit, it was to say, well, there's 20, if we have the majority basically saying there's 28 or 29 students, it's in a way evident that their right trumps. This is an argument we have seen, it's page 274. No one has so far suggested any reason why the will of the parents of one pupil should prevail and that of the parents of the other 29 pupils should founder. I think the German Constitutional Court would see that differently and say, well, it's not a numerical argument. Fundamental rights are anti-majoritarian and the minorities need to be protected. So that's probably the one argument I would not be... And also comes again the question of evidence. Maybe returning to one aspect of the Lautzi case, so if we summarize it, the European Convention does not impose a strict neutrality or a neutrality framework. The court employs an accommodation framework, saying we leave the states a large margin of appreciation. Well, what they can't do is indoctrinate. That would mean active teaching, etc. The cross does not reach that threshold, so we can keep it up. Now the court refers, it's on page 267, paragraph 41, to the decision against Switzerland was a teacher who was wearing a headscarf. And the court accepted the Swiss reasoning, saying, well, the headscarf is a powerful external symbol. And the court also there said, well, it can, in a way, have an impact on the students. Can we square that with Lautzi? Headscarf is a powerful external symbol, it impacts the children, etc. The cross, it's passive, it doesn't do anything.
I think I would understand it because, like, when you have a teacher, it's going to be more active and, most of the time, teachers are also role models. So that could have an impact. And the symbol is just passive, it doesn't talk.